John, perhaps let's start with the basics here. What exactly is diplomatic immunity and how does it apply in this case?
Well, diplomatic immunity is a form of legal immunity. One can almost call it a special kind of legal immunity that ensures that diplomats are given safe passage and are considered not susceptible to lawsuits or prosecution under the host country, and in this case, Ethiopia, although they may still be expelled. And the immunity that we are talking about extends to the family of diplomats. One must just add that diplomatic immunity is governed by the Vienna Convention on Diplomatic Relations of 1961, to which almost all states in the world is a party to, and Namibia is a state party to this. To zoom in onto your question as to how does this whole matter relates to this case, there's a specific article in the convention, and that is Article 31, Sub-Article 4 of the convention, and it states the following, if I may quote in full: the immunity of a diplomatic agent from the jurisdiction of the receiving state does not exempt him or her from the jurisdiction of the sending state. In other words, that as soon as the accused person was sent back, or of course the accused person was expelled and deported back to Namibia, and as soon as that person, the accused person, landed onto Namibian soil, the Namibian jurisdiction fully applied to her in this case. So therefore she can be tried in Namibian courts for the crimes that she is said to have been committed in Namibia. I mean in Ethiopia.
John, what would have happened to the accused in Ethiopia had the Namibian government waived the privilege of diplomatic immunity?
The consequences would have been disastrous. And I'm saying this because Ethiopia is not a state party to the second optional protocol to the International Covenant on Civil and Political Rights, which is aiming at abolishing the death penalty. So as a result, if Namibia were to have granted the waiver as was requested, then Ms. Amutenya potentially, if found guilty, could have faced the death penalty. And for that reason, one must really, in my opinion, one must acknowledge and actually congratulate the government for their refusal to grant a waiver, because, as I said, the consequences would have been disastrous. She could have faced the death penalty. And so basically, what I'm also then saying, Namibia's refusal to grant a waiver in this regard should actually be seen as the government of the Republic of Namibia complying with the spirit and purport of Chapter 3, the Namibian Bill of Rights, in this case, which recognized the right to life, and that basically making a statement saying implicitly that we are not going to be complicit in a process whereby one of our nationals may potentially face the death penalty, whereas under our constitution, the death penalty is totally and absolutely prohibited.
John, notwithstanding that Namibia and Ethiopia do not have an extradition agreement in place, in terms of the law of diplomatic immunity, host countries may expel the criminal suspect from their territory. Does an extradition treaty between countries need to be in place for that to happen?
Like in this particular case, it's a very clear case that no, there does not need to be an extradition treaty in place. That's why when Namibia refused, and I must say here, I'm talking under correction, because the information that we got is in bits and pieces and it's very sketchy. But basically the point is that once Namibia did not grant the request to waive the diplomatic immunity, Ethiopia then expelled and obviously deported the person back to Namibia. And for that reason, one can say, and I'm saying again, I'm talking under correction, there is no need for such an extradition agreement to be in place between the two countries.
John, why did the court rule that the accused was being unlawfully detained? As you rightfully said before, that once a person lands in Namibia, the Namibian jurisdiction is supposed to kick in, isn't it? But where did things go wrong here?
Well, two things. The one thing is that I don't think, and I may be wrong, I don't think it is the court that said that the accused was unlawfully arrested. I think that was the argument of a legal representative. Unless I'm not privy to such information that you're saying, but I don't think there was a court decision in that regard. In terms of the whole arrest procedures, it's that one is innocent until proven guilty. And in this case, my question is that what investigation was done to arrest this person? You don't just arrest someone on, of course, it's not accusations anymore, but did the Namibian police really properly investigate this matter? What evidence do they have to their disposal? That to me is the question. And so the situation that we are dealing with is having much more questions than answers. So strictly speaking, I would say the arrest of Ms. Amutenya was a bit premature, because today we've also heard that they will now approach the Attorney General for a legal opinion as to determine how this matter should be handled. Why didn't you first do your homework, and then once you've established all facts, once you've properly investigated the matter, then only do you then go ahead and arrest the person? And in my opinion, this didn't happen in this case.
John, perhaps I'm missing something here, but don't investigations sometimes take place after the suspect has been arrested? Doesn't that happen in some instances?
But that is not necessarily the correct way, and that's why, and again from the point that I'm standing from, as sitting at, is that that's exactly why we have situations in the country where a lot of cases are thrown out because it was not properly investigated. So Ms. Amutenya has been arrested yesterday or the day before yesterday, but all evidence shows, anecdotal evidence I must say, shows that no proper investigation obviously was done from the Namibian prosecuting team side. That's what I would say. And for that reason, we should not repeat, because you are just weakening your own case by arresting people without having proper evidence and having done a proper investigation.
Lastly, would you say that the decision to let her free is in the interest of justice, the public, and of course, her own?
Can you repeat that question again, sorry?
Would you say that the decision to let her free is in the interest of justice, the public, and of course herself as well?
Yes, I would say so. Once, of course, a very cardinal principle of our criminal justice system is that someone is innocent until proven guilty. And so for that reason, once again, you do not arrest someone and go and make her spend, like what we see in our country, spend so much time in detention whilst giving the police the opportunity to investigate. That, strictly speaking, is not the correct way of doing things. So I would say interest of justice is being served, because it doesn't mean, and I've heard you say she's now being scot-free. She is not scot-free. The case has been withdrawn. But obviously, the withdrawal of a case doesn't mean acquittal. The case would be, as the Prosecutor General mentioned, I've read in today's paper, and also throughout the day, it was mentioned that once all things have been done, proper investigation has been done, they will always now come back, and they can always come back to reinstate the case again. So she's not been acquitted.